Good evening. Good evening. We want to welcome you this evening. We're going to be talking with you about some really interesting, useful information that we hope that you will learn from. We're going to talk about knowing your rights and your responsibilities as a tenant. We thank you for joining in with Fellowship Bible Baptist Church. We would ask that you like this live, share it on your own social media accounts, and subscribe to our page. We are very grateful to have you here, and I am happy to be joined with one of my colleagues, attorney Shannon Mills is going to be joining me. Thank you, Shannon, for joining me this evening.
Thank you for having me. I'm excited to be here.
So we are not going to belabor any points. We're going to jump right into this good information that you have to share with our followers here today. We're going to talk a little bit about the process of renting, whether it's an apartment or a home, and maybe give folks some tips as far as what they should look out for in those situations. So if you could just tell me, what should a tenant know about the process of applying for an apartment or to rent a house?
Okay. What a tenant should know is that they should know the property, whether it's a house or an apartment, what it looks like, and have an idea of what they're expecting. Okay. But also in doing that, you need to have a conversation with the landlord and understand what's their procedure for you applying to rent the house or the apartment. Typically, it involves you providing some information. That may be providing information about your past or previous rental history. They may also have to do a background check for criminal activities and a credit check. And they also may need to know some information about your income, depending on the type of housing. So you need to understand you're going to have to provide some sensitive information, but it's all to enable the landlord to assess you and see if you would be a great candidate for them to rent that apartment or house to you. And also, lastly, some of these applications have an application fee. Uh, Unfortunately, these application fees are non-refundable, but those things are typically some of the costs associated with applying and beginning the process of renting an apartment or a house.
So you said something interesting. My credit could actually keep me from being denied a housing application?
Yes, that's very true. If you have a significant or a history of having a significant amount of credit owed to debtors or other landlords, that may go into the assessment for your landlord in determining if they want to rent that lease or rent that apartment or house to you. And so it's important, but it should not be the only factor that a landlord looks at. And particularly in instances where you are applying for housing in low income areas, such as our HUD funded properties or public housing or Section 8 properties, just looking at your past credit history shouldn't be the only factor. They should also look at your rental history, and they should also play and have some consideration into the time that's transpired since you made the debt or had the debt on your credit, and what are your current economic standings.
So what happens if I apply for an apartment and then my application gets denied?
Okay. What's going to be the determining factor is whether you are applying for private housing or whether you're applying for housing that receives some type of assistance from the federal government. If you're applying for private housing, they may have their own procedure for appealing the denial, but a lot of times they may not. And unfortunately, you may just have to look elsewhere for another landlord or house or apartment to apply for. However, if you're applying for public housing or you're applying to receive some type of federally subsidized assistance, such as a Section 8 voucher, there's typically a process for you to appeal the denial. And what you would do is you should receive a letter stating why you've been denied or that your application for the apartment or to receive assistance has been denied. And then it should detail how you can appeal that. And once you appeal it, which typically involves you calling the landlord or the housing authority and stating you want to appeal. But I would recommend that you do the appeal in writing because that's going to be safer for you and prove that you actually exercise your appeal rights. You should be entitled to have a hearing to discuss and for the housing authority or your landlord to state why they denied your application, and you can rebut that and provide arguments as to why you shouldn't have been denied and why your application should have been accepted.
Now, if I get in a situation where I do get denied and I'm not really familiar with the process on what I should do as far as filing appeal or, making a request for a hearing, is that something that Georgia Legal Services could assist me with?
Most certainly, we provide those type of services, and we'd be happy to try and help you if you have some confusion, understanding why you were denied, or just understanding the appeal process. I would definitely recommend that you reach out to attorney, and if you decide that you would like to reach out to Georgia Legal Services Program, we do provide those services. So feel free to contact us, and we would definitely look forward to helping and assisting in any way possible.
Okay. Now, you mentioned something earlier. You talked about a lease. How important is having a lease?
A lease is it's very important to have a lease, because what it does is it puts in writing all the responsibilities and requirements that are imposed upon you as a tenant, and it also outlines the responsibility and procedures that a landlord has to go through in order to do certain things, such as evict you or charge you for damages to the apartment. And it really provides clarity and understanding for you, and understanding what your landlord can and can't do and what is expected of you as a tenant.
And I think the lease is really important. And we see this a lot in our office. We have clients that will come in and they never read their lease, and they've signed it, but they never really read it. And so they don't know what is actually required of them. And that's part of the reason why we started doing these Know Your Rights presentations, because we feel like when you know better, you do better. And when you know what is expected of you on the front end coming into a lease, then you're more likely to follow through with what you're supposed to be doing as far as that lease is concerned. Would you agree?
Yes, I definitely would agree. And I recommend, before signing a lease, understand it, ask questions. And if you yourself are confused about some things in the lease and your landlord is unable to explain it, or the housing authority won't go into detail with you, contact an attorney, contact Georgia Legal Services Program, and seek some assistance, because once you sign that lease, you're required to follow through with whatever is in the lease. And so you need to be very careful. Of course, there's certain items that they may try to put in a lease that's not valid as far as law is concerned. But if there's a requirement for you to be quiet after 10 p.m. and you're still making noise after 10, you can't say, oh, well, I didn't know that. That could be considered a lease violation. And so you just really have to make sure you understand what your lease is stating, and make sure that your landlord goes through it with you, or contact someone, an attorney, that would help you to understand what's going on before signing.
Before signing. Well, what if I am trying to get an apartment and I go into the apartment and I notice that there are some things that are wrong? And I want the landlord to make some corrections. And the landlord says, okay, I'll do that. How would you proceed going forward if your landlord has made a verbal offer to you to make some corrections in the apartment that you're thinking about renting?
That's a great question. I recommend to my clients that they get everything promised to them in writing, because it is very hard to hold a landlord to an agreement that they made verbally. You need to make sure that you have it in writing, it's signed by the landlord and yourself, and that you keep a copy and your landlord keeps a copy for your housing file. That provides protection for you, and it provides equal understanding of what they are stating that they would do, whether it's to fix this hole in the wall or fix this air conditioning unit. It puts it in writing, and it allows you to enforce it upon your landlord and say, hey, I have this letter, this statement from you in writing that you would make these repairs. You haven't. I'm asking you to do this. And it gives you power to enforce it against them and make them do whatever it may be that they promised.
Okay. So what about renter's insurance? You hear about renter's insurance, and you are well aware that we have people that come into our office all the time and say, I can't afford renter's insurance. It's just too expensive. Can you talk a little bit about renters insurance?
Sure. I would say first and foremost, you want to look at your lease and see if your lease requires you to have renters insurance. Some private landlord leases and Section 8 housing choice voucher landlords require that you get renters insurance for their protection and for your protection as well. In terms of my opinion on renters insurance, I would recommend that if you can afford it, you definitely get you some renters insurance, because what it does is, in case there's anything that happens in the apartment, such as a leak or some type of flooding, something that is out of the control of the landlord, renter's insurance would allow you to get some money back to cover the expenses of damaged property in your apartment or in the house that you're renting. And so I recommend it. And if it's a problem of finding affordable renter's insurance, I've done a quick search earlier this year. And I've seen renter insurance policies as low as $425 a month. It's just really finding a plan that fits your budget and also would allow you to have a decent amount of protection in case things happens. But I would definitely recommend it, and you want to look at your lease to see if it's required.
Absolutely. My rule of thumb is you can't afford to not have renters insurance, because just think, if you lost everything in your apartment and it's not covered as a part of the structure, you got to start all over again. And that renters insurance will help kind of give you a leg up. So let's switch gears just a little bit. We're still talking about some things that are required in your lease or whether or not it's required. And so what I wanted to ask about are security deposits. Tell us how that works.
Okay. So typically in leases, there's a mention of having a security deposit. So what is a security deposit? A security deposit is basically, it's typically 1 month's rent, but it's an amount that the landlord asks that you pay. And what it covers is that should you move or should they choose to not renew your lease and you have to leave the apartment or the house, that amount of money would be used to fix any repairs or damage to the property that is beyond normal wear and tear. Okay. Now, whether or not your apartment or the house that you're renting has a security deposit, it depends on the lease. It's not something that is certainly required for all leases, but a lot of landlords do them in order to provide some sort of protection and cost protection in case a tenant leaves damage. What you should be careful of is the fact that some landlords have been exchanging security deposits for something called a non-refundable lease fee. That is something that is completely separate from a security deposit. With the security deposit, like I said, that amount of money would be returned to you minus the cost for fixing damages beyond normal wear and tear. While with a non-refundable lease fee, you are not entitled to a refunding of that amount that you've paid. And typically, with the security deposit, that is something you would pay before signing the lease. Okay, you would pay that amount before signing the lease. And once you sign a lease, you would pay that amount after signing the lease. Okay. And in order for your landlord to keep your security deposit, they have to go through a specific procedure. If you have to move or you have to leave, I recommend that you provide your landlord some type of written notice stating where they can forward your security deposit to you. That should be a mailing address that you're comfortable with and that you know you'll have access to. And what that does is, should you be entitled to a refund of your security deposit because you didn't leave any damages in your apartment beyond normal wear and tear, or you did leave some damages, but it wasn't the full amount of the security deposit. That's good. That address that you provide your landlord, they're supposed to send that refund to you. Okay. And they're supposed to do that within 30 days of you moving out. So providing that written statement of a forwarding address is great. But also, before you move out, you need to take pictures of your apartment. And I recommend pictures or video so that you can have something to contest the condition of the apartment, because your landlord might say, hey, there was a hole in the wall, but when you moved out, there wasn't a hole in the wall. And so you don't want to be charged for damages that you did not actually leave in the apartment or the house that you're renting. So having those pictures and the video would allow you to have some type of defense or protection against those landlords who may try to charge you for things that weren't there. And like I said, anytime that they're charging or keeping your security deposit, you should receive some type of written notice within 30 days that either refunds your security deposit back or tells you in list form those damages that were charged against your security deposit and how much the estimated cost was. If you're not receiving that within 30 days, that's a problem for the landlord, and there's a chance you can receive your full security deposit back.
Okay, and so let's just say I moved out. I didn't have any damages. I made sure that they had my forwarding address, and they never sent me my security deposit. What should I do?
What I would do is that you should definitely contact an attorney because they're going to be able to help you to enforce your rights that's entitled to you in getting that security deposit back. Because if it's beyond those 30 days and they haven't given you any notice, they're operating outside of what's allowed in Georgia law. They may be operating outside of what's allowed for Georgia law with security deposits. And like I said, you can get a full return of your security deposit back or more if it's proven that they've been doing some wrongdoing. So definitely, I would say reach out to an attorney or contact Georgia Legal Services Program. And we'd be willing to assist you in seeing what's going on with the security deposit back and how can you get the refund that you are entitled to, depending on the circumstances.
Now, you talked about a move-out inspection to make sure that you cover yourself based on the condition that you left your apartment in. But do you think it's important to do a move-in inspection, a walkthrough with the landlord, or even doing it on your own?
Yes, having a move-in inspection is very important. I would recommend doing the move-in inspection with the landlord as well. And typically what happens is before moving in, you go through a walkthrough with the landlord, and there's a list of items in the apartment or the house. So they might have a section for the kitchen, a section for the bedroom, a section for the living room. And as you walk through the apartment or the house, now this is before you've moved in, it's notating the condition of the apartment, the condition of that specific thing. So it might say the countertop has a scratch on it, or the kitchen has a mark on the stove. That is critical information because anything that was there before you moved in is not something that you caused. It's just notating the condition before you moved in. And why the move-in inspection is so important is because you need the move-in inspection with the move-out inspection. And it's used to compare where the apartment or the house was before you moved in and where it was after. And anything that is in excess of normal wear and tear is going to be something that they can charge against your security deposit. Now, what is normal wear and tear? You may wonder. Normal wear and tear, you have to think of it as while you're living in an apartment or living in a house, you're going to be expected to have certain things that just normally wear out as you're walking on a carpet day in, day out over the course of a year, over the course of your lease. You can expect that carpet's just going to wear down somewhat. And so in thinking about that, the law defines that as something that would normally happen. Now, what is something that is in excess of normal wear and tear? A hole in your wall. You wouldn't normally expect a hole to occur in your wall. That's not something that just normally happens during the ordinary use or living in an apartment. So anything that is in excess or something or damage that happens that's out of the ordinary, that's going to be more than likely beyond normal wear and tear. And your landlord can charge that damage to that cost to fix that damage against your security deposit.
Okay. And another good point, if you have something that you noticed in your move-in inspection that needs to be corrected, something that you want to get fixed, something that the landlord says we'll take care of, I would say take pictures of that, make notations of that, get that type of documentation, like you said, in writing so that you can follow up and you can make a written request to the landlord. If they don't get it done in a reasonable amount of time, you can show them the list of things that you all agreed upon, and then you have some documentation to provide proof if you ever end up in court on this issue.
Yes.
So let's talk a little bit about repair and maintenance issues, Shannon. What type of responsibilities do landlords have when it comes to making repairs and maintenance on a unit?
Okay, landlord typically has the responsibility to make sure that the unit, and that's the house or the apartment, is in a safe and habitable condition and in good repair. So if something is out of repair, such as your stove or your refrigerator, your landlord or your AC unit, especially in these times where it's getting hotter and hotter, your landlord has a responsibility to make sure that that is in good repair. Because, for example, having something like your air conditioning unit not working in the summer where temperatures can rise to 90 degrees plus, that's definitely something that's going to affect the habitability of you living in that apartment or house. And so with those type of things, your landlord has the responsibility to make sure that they're operating in a safe condition, it's that your apartment is in a safe condition and that it's habitable for you to live in.
So how would I make a maintenance request? Let's say my stove just stopped working and I need to get it fixed. How would I go about making that request to my landlord?
Okay, I recommend that you put the request in writing. Okay. Now I know some apartment complexes and landlords have a online reporting maintenance request. That will work as well. But regardless, you need to put the request in writing. You need to have your name on the request, state specifically what's the problem and what you would like repaired, and then sign it. I would keep a copy of that request for your own records. Make a copy of it. Make sure that the date is on it as well, because that's very important. And then you provide that original notice, that original maintenance request to your landlord. Okay. And what they're supposed to do, what landlords are supposed to do, they're supposed to make a response or respond to that maintenance request within a reasonable amount of time. Okay. Now, what is a reasonable amount of time? That's going to be dependent upon the thing that you're requesting to be repaired. And so, an example I like to use is that if you have you have a leak from your sink or in your bathroom, and it's currently running, it's going, and it's still leaking, and it's starting to flood. A reasonable amount of time for that type of repair would be very quick, because it's something that's continuing to generate. It's a problem that's ongoing and it's causing damage consistently, continuously. Okay. So I would say that a landlord needs to address that repair, that maintenance request as soon as possible. Now, to contrast that, if you have something like a scratch on your wall that wasn't caused from you, okay, then what would be a reasonable amount of time for that? You could expect a reasonable amount of time for a landlord to address that would be would be longer than it would be with the issue where you have an ongoing leak, because it is not something that is causing a continuous problem. It is a problem that you might have a scratch or a hole in your wall, but it's not to the same, it doesn't require the same level of urgency as if you have an ongoing flood or leak in your bathroom. And so when you're making these maintenance requests, you have to be mindful of a reasonable, what may be expected as a reasonable amount of time for your landlord to respond to the request.
Okay, so I've made my request and my landlord is ignoring me. And can I just decide, well, you know what? If you're not going to fix whatever's wrong in my apartment, then I'm just not going to pay you any rent, because it doesn't make sense for me to stay here and pay you if you're not going to fix what's wrong with my apartment.
No, that is a big no. The responsibility for your landlord to make repairs is something different from your responsibility as a tenant to pay rent. And in the court and in the law's eyes, they're two separate things. So your landlord failing to make repairs, it does not excuse you from meeting your responsibility of paying your monthly rent, so long as you are staying in the apartment or the house that you're renting. So what I always say to my clients is that, yes, you may be frustrated that repairs aren't being made, but as long as you are staying there, continue to pay your rent, and we can work on enforcing your right to a safe and habitable apartment or house against your landlord and making them make the repairs. However, if you fail to pay your rent and your landlord takes you to court, it essentially gives them a way to get out of ever making those repairs, because they can file that eviction. The court is going to look at whether or not you paid rent and you stayed in the apartment. If you stayed in the apartment or the house and you didn't pay rent, they can grant that eviction, you can be evicted, and your landlord still hasn't made repairs. So make the make the rent payments and contact an attorney and or contact Georgia Legal Services Program, and we can help you with making your landlord make those repairs to your apartment. But don't make the problem worse by failing to pay rent, because that can lead to an eviction.
Okay, so let's talk about your example. You've got the leak in the ceiling and the water is dripping and it's a problem. And I figure I'll just go and get somebody to fix it for me because my landlord's taking too much time. Can I just do that and then get my money from the landlord?
You should give your landlord notice. I wouldn't just do that without talking to the landlord. What you're doing is something that's called repair and deduct. And it's in those instances where your landlord hasn't made repairs within a reasonable amount of time. And if you want to pursue having that repair concern addressed in that way, what you should do is, after the reasonable time has passed, send another notice or a letter to your landlord that you keep a copy of as well, and that's dated, that states you are seeking outside maintenance men or repairmen to come and address this issue. You know, whether it's an AC issue, it's a hole in your wall, or something going on with your carpets. You should give that notice to your landlord and let them know that you're seeking that type of assistance and that you intend to deduct that cost to get the repair concern addressed from your rent. But you need to give your landlord that notice so that in case they decide to actually make the repairs, they can do so before you pay for the maintenance men. But however, if you send that request and your landlord doesn't respond after a reasonable amount of time, then you can get those repairmen to make the adjustment, but it has to be something that wasn't caused, it has to be damage that wasn't done or caused by you, by the tenant or your guests. And also, it has to be the reasonable cost to get that issue repaired. Okay. It can't be something such as my sink stopped working, so I replaced it with a high priced gold plated sink. You know, that's not going to be reasonable. It has to be the reasonable cost to replace or fix that repair concern. And then what you can do is deduct that cost from your next month's rent. And that is something called repair and deduct. And that's allowable in certain circumstances, but it's very sophisticated. And I recommend that before you do that, you contact the attorney, contact Georgia Legal Services Program, and seek some assistance. Because if you make a mistake in the process and you don't provide the proper notice or allow the correct amount of time for your landlord to make the repairs, what you could have is a eviction filed against you for not paying the full amount of your rent. Or your landlord may not even accept the partial payment of your rent, and that would still allow them to file an eviction against you for non-payment of rent. So I recommend you definitely contact an attorney, contact Georgia Legal Services Program, and get some assistance before doing repair and deduct.
So you said the ugly word, you said eviction. So let's talk a little bit about that, because we get clients that call us all the time that say, my landlord said I've got to be out by Friday or they're going to put my stuff out on the street. Talk us through the eviction process and how that actually works.
Sure. For at the beginning of the eviction process, let's say your landlord has decided, I've had enough, I want to evict you. Your landlord has to give you what's called a demand for possession. Now that's a notice that states, hey, we want you to leave. We're demanding possession of the property by this date for this reason. If you don't do so, we're going to file what's called a dispossessory affidavit. And that's typically filed in the magistrate court. The dispossessory affidavit is a simple document. It states the landlord's name, the property, and the tenants. And it also lists the reason as to why they're requesting that the courts intervene in order for the landlord to retake possession of the property. They filed that in the magistrate court of the county where the property is located, and you should then be served something from the sheriff. That something is the dispossessory affidavit as well, and it's gonna state on the dispossessory affidavit why your landlord is trying to evict you, and it's also going to require you to file an answer with the magistrate court within 7 days of you being served that document. Now, what's important is that you're supposed to be served some way, somehow. Now, there's different forms of service. There's service where the sheriff may knock on your door and hand deliver you the dispossessory affidavit. But there's also what's called tack and mail. Tack and mail is where they're unable to locate you, the tenant that they're trying to serve the dispossessory affidavit. They're unable to find you and personally hand deliver you. So what the sheriff does, they tack the dispossessory affidavit to your door, and they're supposed to also mail you a copy that same day. Now, what's important about tack and mail is that it provides some strategic use depending on the reason why your landlord is trying to evict you. If your landlord is trying to evict you for non-payment of rent, and this is for non-payment of rent only, and you are served via tack and mail, you have the option of not responding in court with an answer to the dispossessory affidavit within 7 days. What that does is it enables your landlord to get default judgment for possession of the property. So you would essentially be evicted. Your landlord could retake possession of the property. However, in non-payment of rent dispossessories, your landlord is not only asking for possession, but typically they're asking for the amount of money owed. And so not responding in a tack and mail service situation and getting the default judgment, the judge only grants possession. The judge does not grant the possession as well as the monetary judgment. And so if you are in a situation where you have decided that you are already going to leave, you're already going to move out of your apartment or your house, strategically, and you've been served through tack and mail, strategically, you can choose not to respond in the 7 days, move out, and avoid your landlord automatically getting a monetary judgment for the rent that you've owed. But it only provides that tack and mail service only provides that strategic use in those instances where your landlord is asking for an eviction based on non-payment of rent, as well as a monetary judgment for the rent that's actually owed.
So before you decide to use that defense, you probably want to talk with legal counsel to make sure that it's going to be in your best interest, right?
Yes, you definitely want to talk to legal counsel. Get an attorney, contact Georgia Legal Services Program, and speak to them about that. And you need to do it as soon as possible. As soon as you're served, the earlier the better, because then that enables you to have time to talk to the attorney and also figure out what your objectives are. There are some instances where you may want to contest the eviction in court and have your day in court and defend against the eviction before a judge. But if you're planning on leaving already, you may not want to pursue that. And it may be better, in your opinion, considering your circumstances, it may be better not to answer the dispossessory in court and instead just leave, and you would have the eviction on your record, which is going to be available for the public because it's public record, but you wouldn't have the monetary judgment against you for the rent owed.
Now, one thing I do want to point out as well while we're here is if you get served with a dispossessory, you need to seek some legal counsel immediately. You only have 7 days to file an answer. You don't want to contact a lawyer on the 7th day and say, hey, I have this, I don't know what to do with it, because you really could be hurting your case. And so you want to seek some legal counsel as early as possible so that they can assist you with developing a strategy, helping you file an answer, because there are situations where you may have a counterclaim against the landlord. Maybe they're suing you for eviction, but you have counterclaims based on the conditions that you've lived in or what have you. And if you don't raise those counterclaims within a certain amount of time, then you lose the right to do so. And so that's why it's important to talk with an attorney about those types of things.
Yeah.
So let's say I lose when I go to court. I don't call Shannon Mills, attorney Shannon Mills at Georgia Legal Services, and I try to do it on my own and I lose. Is there any right for me to appeal or anything after I lose that case in magistrate court?
Yes, it's not over. There's an appeal process. And what that involves is after the judge has signed the order and issued the judgment, you have 7 days from the date of that judgment being signed to file an appeal with, typically it's going to be in the superior court, but some magistrate courts may refer their appeals to the state court. What you need to do, and after you decide you want to appeal, you need to go to your magistrate court, inform them that you want to appeal, and typically they're going to give you some instructions because some courts you have to go straight to the higher court that you're appealing to, state or superior, and file the statement of appealing, or you have to work through the magistrate court and they begin the process in helping you and filling out the forms required to let the court know that you're appealing and you want to have another hearing to discuss this before another judge. Now, at this hearing, let's say you file the forms within 7 days. In filing the forms, let me go back for a second. In filing the forms, there may be a charge for a filing fee to file the notice of appeal. Okay. I recommend that if you cannot afford the filing fee, you fill out what's called a pauper's affidavit, and that would allow you to waive the filing fee. Now you're going to have to provide information about your income and your expenses. But if your income is determined to be such that you cannot afford the filing fee, that filing fee can be waived, and you will be allowed to file the notice of appeal for free. Now, once you've gone through that process, you filed it. The court is going to schedule a new date for another hearing in that next higher level court, state or superior court. Okay. While this is going on and you want to continue to stay in the apartment or house you're renting, you're going to have to pay into court, into magistrate court, the trial court where you initially started. You're going to have to pay into that court the rent that you would normally pay to your landlord. Now, it's very important because if you decide that you do not want to continue to stay in the house or apartment you're renting, you can move out and you won't have to pay that amount into court. However, if you want to continue staying there, you need to pay that amount into court every month. And if you fail to do so, it could lead to the eviction being granted and you being forced to leave. So that's very important. Now, at that appeal hearing, you will be allowed to represent your side and your landlord can present their side again, and then the judge will issue a new ruling. Now, once the judge issues that ruling, you can continue the appeal process, but it becomes harder because when you are appealing from magistrate court to state or superior court, you're doing so under what's called de novo review. It's a legal term, but basically it allows you to start fresh. It allows you to start the hearing. Nothing from the previous hearing has bearing on the appeal hearing, besides the fact that the judge in the magistrate court issued a decision that you disagreed with, which is why you're appealing. However, when you're appealing from that appeals court to the next level, which would be the Court of Appeals, the only basis that you can really appeal is because there's been some error in law or there's been some error in judgment on the judge's part. You would not be able to really re-argue the facts of what happened or stating, well, he stated I damaged his property. I didn't. He stated that I didn't pay rent when I actually did. So it's very important to really look at and evaluate whether you want to do appeal. I would recommend also contacting an attorney as soon as possible because they're going to be able to tell you what type of scrutiny or what things you would have to prove in winning the appeal, and they would help you in filling out the appropriate documents. So contact an attorney, contact Georgia Legal Services Program to get some help if you decide you would like to appeal an eviction granted against you.
We are in the middle of a pandemic. There are people who are really struggling, people who have lost their jobs, they've lost their income, they may not be able to pay their rent right now. We are anticipating that the number of evictions that we will see very soon is high. You hear this term of art, the CARES Act. Can you explain for us briefly what that means to the general person? How can that help somebody who is in that situation?
Sure. The CARES Act covers a number of things, but it was primarily passed in the wake of the COVID-19 pandemic that's still currently affecting people all over the world. And it provides protections for various things, but the thing that we're most focused on is the protection it provides for tenants. Okay, what you need to know about the CARES Act: it stops landlords from being able to file evictions against tenants for non-payment of rent only. For non-payment of rent only. It's not for other reasons why they may be terminating your lease or trying to evict you. It's only for non-payment of rent. It stops those landlords in certain properties. It's not all landlords, it's only certain landlords. It prevents them from being able to file evictions against their tenants for non-payment of rent. And it also stops them from charging those tenants late fees for not paying their rent. Now, this CARES Act passed on March the 27th, 2020. It lasts currently 120 days, meaning that its end date from March 27th, its end date will be July 25th. And that's the length of its protections, okay? Going into something that I stated earlier, it only protects certain properties. Those properties, public housing, any property that receives Section 8 assistance from the federal government, and a whole list of other federally subsidized housing apartment complexes, because there's a growing list of different subsidies. But some of the big ones is public housing, Section 8, and it's also low-income housing tax credit properties. But there's also another really not federally assisted housing, but it's properties of 1 to 4 units that are backed by a federal mortgage. Okay, so what you would have to do is speak with your landlord, see if they bought that property using some loans or some money from a federally backed mortgage. And if they are, then you are also under the protections for the CARES Act. And so, like I said, your landlord would not be able to evict you for you failing to pay rent from March the 27th all the way through July the 25th. Now, this act may be extended. If it's extended, then you're looking at extending that time frame beyond July the 25th. But in between those times, from March 27th to July 25th, they cannot evict you for failing to pay rent. Now, the situation that this sets up is after July the 25th, what happens? Well, after July the 25th, your landlord is supposed to give you a new 30-day notice that states, hey, you owe us rent and we are expecting you to pay within these 30 days or work out some payment plan, else we're going to file an eviction against you. And so they're supposed to give you an additional 30 days beyond July 25th, assuming that the act isn't extended. So you're looking at around August the 25th before they can file an eviction against you for failing to pay rent between March the 27th through July 25th. Now, it's encouraged that these landlords and public housing authorities work with the tenants to establish some type of payment plan for those months where the tenants were unable to pay rent, but they may not want to work with you. I recommend that if you run into those situations or you need help talking to your landlord and trying to get a payment agreement, contact Georgia Legal Services Program or contact an attorney and see about getting some assistance. Because typically I've been able to get inside of those negotiations, those conversations, and speak to the landlords, and we've been able to reach a payment agreement that works according to the tenant's economic circumstances and allows for the landlord to be paid back eventually, while also not burdening the tenant with having to pay thousands of dollars in rent because they were not working during the COVID-19 pandemic. So definitely contact the attorney, contact Georgia Legal Services. We'd be glad to help you in trying to negotiate that.
Okay. As we prepare to wrap it up, I want to say thank you so much to the City of Warner Robins for co-sponsoring this presentation today. They give us the ability to go around and do presentations where we talk about things like fair housing. And so that's my pitch to you. At this point, if you could just briefly just kind of explain to us what fair housing is and what type of protections there are for some of our listeners.
Okay, so fair housing It relates to the Fair Housing Act. That is a part of the Civil Rights Act of 1968. And what it establishes is that there should be no forms of discrimination in the renting, selling, and advertising of renting properties to the public. And it protects specific groups of individuals from being discriminated against by actions from those who are selling or renting houses and from landlords. It protects classes, meaning that you should not be discriminated based upon race, ethnicity, religion, national origin, sex, as well as disability and familial status. Because you see a lot of instances, some landlords may pass or have a rule in place that infringes upon a household based on the family size that they have. All of those type of forms of discriminations are prohibited against via the Fair Housing Act. And if you are in a position where you feel like you are being discriminated against because of your national origin or because of your race, because of your color, because of your sex, because you are disabled, you need to contact the Department of Housing and Urban Development, or more specifically, if that may be, you may not know who to contact an attorney or contact Georgia Legal Services Program, and we can point you in the right direction of where you can go to get some help to address that discrimination that you've been on the receiving end of. Because there are things in place and protections in place to stop you from being discriminated against based on those characteristics. And you can definitely get the rights and get the justice that you afforded to prevent that type of discrimination from going on, because Fair Housing Act protects against that.
Awesome. Thank you. Shannon, thank you for joining us today. We have come to the end of our time. We want to thank Fellowship Bible Baptist Church for allowing us to use this forum. We were so looking forward to doing this presentation live at the church in March. And then things changed drastically. And so we appreciate you giving us the opportunity to come here and share this information. Georgia Legal Services is a statewide nonprofit law firm. The Macon Regional Office covers 23 counties in the Central Georgia area, and we are here to help you. Housing is just one of the many things that we do. You see our number on the screen, and if there's anything that our office can do to be of service to you, then we ask that you reach out to us. Again, thank you so much for joining us today, Shannon, and everybody have a great evening.